record for Monday morning civil docket, May 16, 2022. And Mr. Alamia, what do you have, sir? Oops, you're on mute, Mr. Alamia.
I have a divorce, uncontested, no children, no property on. By way,
Okay. And that is that Michael Ayala and April Ayala?
yes, Your Honor.
Okay. And is Miss Ayala going to be present today?
No, she's not. She signed a waiver. Michael Ayala is present.
All right, F3677-21-9, Michael Lee Ayala versus April Marie Ayala. Mr. Ayala, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you may lower your hand. Okay, go ahead, Mr. Alamia.
Thank you, Your Honor. Is your name Michael Lee Ayala?
Yes,
Are you married to April Marie Navarez Ayala?
yes,
Have you lived in the county of Hidalgo for at least 90 days?
yes,
State of Texas for at least 6 months?
yes,
You were married on or about September 15, 2014,
yes,
separated on or about April of 2017.
yes,
Has your marriage become insupportable because the conflict of personality between you and your wife that destroyed the legitimate interest of the marriage relationship?
yes,
There was no children born of this marriage, adopted or expected, is that correct?
yes,
There was no community property or community debts accumulated during this marriage, is that correct?
yes,
And you're asking for a divorce, is that right?
yes,
That's all we have, Judge.
Okay, then the court is taking judicial notice of all the documents in the court's file, specifically the waiver of service that was filed back on March 2022. The court is granting the relief as requested and testified to on the record by the petitioner. Do you have a final decree of divorce on file?
I'll prepare it this week and submit it, Judge.
All right, I'm gonna set a tickler for May the 27th to make sure that it's submitted.
Thank you, Your Honor. That's all.
Okay, you have a great day.
Thank you.
Okay, Mr. Banker, what do you have?
Yes, Judge, number 14 on your docket.
CL 21-1841-I, Midland Credit Management versus Carla, Karlam De Leon.
Yes, Judge, a couple months ago, we filed an answer on this. Mr. Newman has never appeared. He's attorney of record. Every time we've made appearances, there's been a local counsel that has made some announcement. We've made effort to communicate with Mr. Newman through phone calls and emails, but have yet to have a response. I'm not sure if they're wanting to continue to prosecute this matter or not, but I'm here. I'm not sure if anybody's going to appear on his behalf or him. So.
Okay, is anyone here on Midland Credit versus Carla De Leon? Okay, there isn't anyone making an announcement on that case. Well, you can file your motion for them not prosecuting, or I can set you on the drop docket.
Let's put it on the drop docket, Judge. I think that's a good idea.
Okay, let's go ahead and let me see.
Your Honor, we can put it on May 27th.
Okay, well, that's you mean June 27th?
I'm sorry, Judge, yes.
Okay, yes, we can set it for the drop docket. For June, well, actually, you know what? We can set it for June the 6th at 9:30. We'll set it sooner so we can try to see if they're gonna do anything.
No problem, Judge.
Okay, June 6th at 9:30, and I believe that's our drop docket in the morning, correct?
That is correct, Judge.
Okay, all right, so we'll do it June 6th at 9:30. We'll set it for a drop and then we'll see what happens. Anything else, Mr. Banker? Mr. Banker,
Judge, the only
anything
concern I
else?
have about, excuse me, Judge, I'm sorry, I was on mute. The only concern I have on that date is I have several cases on my calendar that include live appearances. I
Oh,
don't think we ought to, if it'd be okay, get another date. And even if it's later in the month, that's fine too.
okay, then we'll go ahead and go with the June 27th.
Sounds good. Thank you so much. May I be excused?
Yes.
Thank you, Judge.
Okay, anyone else with quick announcement before I just go down the docket? Okay, Ms. Thompson, what do you have?
Yes, Your Honor. Number 6 on the court's docket.
F 2743-21-9 in the matter of the marriage of Jacobo, Jacobo Garza versus Gabriela Paez, Paez. Go ahead.
Yes, Your Honor. The parties filed a joint motion for continuance, but it wasn't filed until early this morning. So I'm here to ask if we can have a continuance with a reset date.
Sure, how much time are you needing?
About 30 days.
Okay. You need further than June 13th?
That should be sufficient, Your Honor.
Okay. Hold on real quick. All right, June 13th then? At 9:30. Do you anticipate that it'll be agreed to or contested?
Yes, Judge, it should be agreed.
Okay,
Thank you, Judge. May I be excused?
yes, ma'am, no problem.
Thank you.
All right, Mr. Ramirez, Attorney Dennis Ramirez, what do you have, sir?
Good morning, Judge. I have number 18 on the court's docket this morning.
Okay, good morning, sir. F 4436-21-9, in the interest of a minor child, is Mr. Cavazos present? I saw him on.
I thought I saw him on. That's the reason I took the liberty to announce, Judge.
I think he must have logged off,
Okay.
but he was
well, Judge,
present.
I'll be on standby then. That's the only reason I thought I saw him, Judge. I wouldn't try to announce without him. So I'll be on standby. I am in an in-person hearing here at the courthouse, so I had stepped out, but I'll have it on, Judge, and I'll be available.
Are y'all still working on it, or are there issues, or?
I believe that we're still working on it. I know I did talk to my client, and she advised me the visits have been going. There was maybe one missed one due to illness or some other issue, but she was ready for some more. Mr. Cavazos did reach out to me last week, but I was tied up in some contested matters. So, and I know it was originally set last week. The court moved it to this week. It may be appropriate to maybe another week or two, Judge, so that he and I can confer, because otherwise I believe it's just an announcement today.
Yes, it's just status. So
Yes.
let's go ahead and we'll do June the 13th at 9:30.
Thank you, Judge. And I'll let Mr. Cavazos know. I'll send him a text message right now.
Okay, and then at that time, if y'all happen to have something worked out by then, we can go ahead and take it up.
Thank you very much, Judge. I appreciate the court's time. May I be excused, Your Honor?
Yes,
Thank you.
okay, thank you. All right, Mr. Theodina, what do you have, sir?
Sorry, I need, Your Honor, I'm number 15 on your docket. I have a status conference with Mr. Lucio.
Okay,
Morning.
and I did see.
Morning, Your
Mr.
Honor. Eddie Lucio
Lucio.
here.
Okay, CL 21-3325-I, Juan Gaitan Jr. versus Stephanie Stephanie Almaza. And what is the announcement?
Your Honor,
Judge-
we're announcing, ready for this one?
Okay, so then
Do
you
we-
all you're ready to get some DCC for trial dates or what?
Correct, Your Honor. Correct. We need a DCC and trial dates.
Have y'all already mediated or not yet?
We have not meted it yet, Your Honor.
Okay. How's there, and what about discovery? Have y'all already gone through and gotten your depots and all that stuff?
We've exchanged the paper discovery, and the next step is to take the depositions in this case.
Okay, go ahead and file your motion for DCC. We'll get you set up and then we'll get you your trial dates and deadlines.
Thank you, Your Honor. We'll take care of that.
Thank you, Judge.
May I
Okay,
be
you'll
excused, Your
have, May 27th is a tickler that I'm setting for that. So just get that in before then, please.
Understood, Your Honor.
Okay, thank you. Y'all have a great day, gentlemen.
You too, Judge. Thank you.
Thank you. Okay. Ms. Lopez Singletary?
Good morning, Judge. I am here, number 7. We have an agreement in reference to a divorce. Your Honor, I don't see Mr. Contreras logged in. I did call him earlier too to confirm with him, but I just don't see him logged in. I know my client and his client are both logged in.
Okay. Did you file a counter petition?
Yes, we did, Your Honor.
Okay, it's up to you. I can take the testimony up since it's an agreement, or if you'd like to wait for him.
I'm
it's
gonna
fine.
wait, Your Honor, because there is one issue on the summer visitation that we don't have agreed to, Your Honor.
Okay, no problem.
Thank you, Judge. If the court can recall this.
Sure. Okay, Mr. McInnes, what do you have, sir?
Judge, we have a status hearing on number 17.
Okay. F3398-21-9 in the matter of the marriage of Jorge, Jorge Compian, Compean versus Kenya, Kenia Compian.
Kelly McInnes here for the petitioner. Good morning, Judge. Judge, this case had been set for final hearing and we tendered testimony. There was one issue that we did not know, and it's come up, and that is that there's a child support order in another county. We have hunted down the county. It's in Dallas County. We've got the case number, and I think the only way we can handle it is to file a motion to transfer venue in the Dallas case, get it transferred down here and then consolidated. So
Yes.
there's a 45-day minimum time. We're working on the motion to transfer venue, but we have to give 45 days notice under the rules. I think it's Rule 86 or something like that.
Yes.
So we can maybe reset this for about 90 days down the road. Hopefully we can get all that stuff taken care of.
Okay, do you think August 29th?
Let me check that date, Judge.
Okay.
Yeah, that date's fine, Judge.
All right, August 29th at 9:30.
Thank you, Judge. I have nothing further. May I be excused?
You certainly may, sir. Have a good day.
Bye-bye.
Okay. Mr. Sanchez, which one of the cases are you here on?
Judge, I'm under pro se divorce on F 1749-21-9, the intervener.
Okay, I do see that Mr. Richard Flores is on. I'm not sure if Berta Flores is present. Okay, you're under Letty Flores? Okay, Mr. Richard Flores, I'm gonna ask you to pull over safely so that you can participate in this. Let me go ahead and look this up, Mr.
Well, if you
Sanchez.
just, yeah. Yes. Well, I'm actually headed down to the valley if we can reschedule, because I have to catch a flight right now, so I'm not gonna be able to stop because then I'm gonna miss my flight. But I am headed to the valley if that helps. I don't know if we can reset or if we can just go ahead and just get divorced because we have a care plan, we have an agreement, we have everything that was needed. You know, I mean. There's no
Okay,
property,
the only
there's no-
thing the thing is that the Office of the Attorney General has filed an intervention. And the terms of that, the terms of that intervention are not in your divorce decree that you filed. So that's the issue.
We did file, we did submit a form where we both agreed on, what would work best for our situation, Your Honor. And we were told to file it as Exhibit 1.
Okay, yes. However, Mr. Sanchez, have you had an opportunity to review the divorce decree that was submitted by the parties?
Yes, Your Honor, we did review the divorce decree, the proposed decree. We just cannot agree to zero support.
Correct.
It's the only issue that.
Okay, Mr. Flores, how much time will you be here in the Valley?
I'll be there more than 30 days. So I'll be there for about, I'd say, give it a month and a half.
Okay,
Yes,
Because
ma'am. I'm headed there tonight, so I'll be there tonight.
okay. Because I think what would best serve is for us to do this in person, because I don't believe I need to explain to you so you all can see what's lacking. So since you're gonna be here, let's go ahead and come back on June 1st at 9:30. That
That
will
sounds
be
good.
in person. And that way I can tell you what you all are lacking.
Okay.
Mr. Sanchez, that will be in person,
ma'am.
Mr. Sanchez.
Yes, Your Honor. We'll be here.
Okay? All right, thank you. Y'all have a great day.
Thank you,
Thank you.
Judge. Maybe it's
Yes,
you.
ma'am.
Yes,
God
you may.
bless.
Thank you. Okay, Mr.
bless
Cavazos,
you.
Attorney Jaime Cavazos.
My exit.
All right, Miguel Vargas.
Yes, Your Honor. Good morning.
Good morning, sir. Okay, so you're here with Grisela Gonzalez?
Grisela Trejo.
Okay, Miss Gonzalez, or Trejo now? Okay.
Yes.
Mr. Vargas, let me just, are you at your attorney's office?
Yeah, no, I'm in my
No.
office,
Okay,
but I see Mr. Guerrero, which is my lawyer, and he's online.
well, I do see that he has another case that's here. I don't know, Miss Molina, do you want to let them know that we're ready for Mr. Guerrero?
Sure.
Thank you. As soon as he gets on, we'll go ahead and take him up.
Okay.
Who's here in the interest of a minor child? I'm sorry, no, Ivana Frias? Ivana Frias? And on number 5 on the court's docket, did anybody call in?
No, Judge, I don't believe so.
Okay.
I'm just checking the queues, Judge, to see. No, we haven't received anything either, Your Honor.
Okay, Ana Cárdenas, Eduardo Cárdenas. Has anybody called in on number 9?
Not that I'm aware of, Your Honor.
Okay, Elma, Edith Martinez, Jose Martinez. Elma Martinez. Okay, Ms. Lopez Singletary, Mr. Contreras is now on the screen. Let me go ahead and recall F2799-21-9 in the matter of the marriage of Kathleen Kathleen Guerrero versus Adrian Cardosa.
Yes, and good morning once again, Your Honor. Ana Lopez Singletary here on behalf of Mr. Adrian Cardosa. We are set for a final, Your Honor, and we do have an agreement. Mr. Contreras and I have gone over the terms and conditions. There's only one, Your Honor. We can leave that towards the end. Maybe the court can guide us, or maybe Mr. Contreras and I can enter into an agreement.
Okay.
Okay.
Actually, what the judge is saying, Your Honor, that's correct, Your Honor. We have an agreement.
Let me go ahead and have the parties get sworn in. If Ms. Guerrero and Mr. Cardosa can go ahead and unmute themselves. All right, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Ms. Guerrero, yes or no?
Yes.
And Mr. Cardosa, yes or no? I can't hear you, sir.
Sorry.
There you are.
How's it sound?
Better.
All right, awesome. Yes.
Okay, you both may lower your hand. Okay, who'll be proving it up?
I can prove
Judge
it.
Singletary, can you do that for me? I've been up and down this courthouse right now, and notes all over the
for you.
place.
Yes.
Thank
not
you,
an
thank you,
issue.
Judge.
Okay.
Appreciate it.
Okay, all right, Mr. Cardosa, please listen to the questions of your attorney carefully. Go ahead.
So, Mr. Cardosa, you've been a domicile of this state for the past 6 months. Is that correct?
I'm sorry, what was the question?
You've been a domicile. You lived in the state of Texas for the past 6 months. Is that
Oh,
correct?
yes.
And you've been a resident of Hidalgo County for the past 90 days. Is that correct?
Have I been arrested?
Resident.
Resident. Oh, yes.
Okay.
Sorry.
And okay. And Mr. Cardosa, you are currently married to Miss Caitlin Guerrero. Is that correct?
Yes.
You and Ms. Guerrero married on or about December the 1st of 2018, and you separated on or about June the 1st of 2021. Is that correct?
Yes, ma'am.
And your marriage to Ms. Guerrero has become insupportable because of discord and conflict that destroys the legitimate ends of the marriage. Is that correct?
Yes.
And there is no reasonable expectation that you and Ms. Guerrero are going to reconcile. Is that correct?
Yes, ma'am, that's correct.
Okay, now out of the marriage, you had 2 children, Tristan James Cardosa, born on October the 3rd, 2017, and also Ella Marie Cardosa, born on October the 15th of 2021. Is that correct?
Yeah, it's January 15th.
And no children were adopted, correct?
No, ma'am.
2015, yes, correct. And then to your knowledge, Ms. Guerrero is not expecting a child at this time, correct?
No.
Okay, now you and Ms. Cardosa have entered into a parenting plan, and these are the terms and conditions of that plan. That both of you be appointed joint managing conservators of the minor children. Ms. Caitlin Guerrero will be primary with the right to designate the residents within Cameron, Hidalgo, and Willacy counties. That you will be ordered to pay child support in the amount of $420. That is of May 16th of the year 2022. That Ms. Cardosa will carry the medical support for the minor children, and you will reimburse Ms. Guerrero in the amount of $531 with 62 cents per month. You will also be in charge of dental support. The possession standard for visitation is going to be in 2 different provisions. For Tristan, you're going to be exercising visitation as per the standard family code on the 1st, 3rd, and 5th of Fridays of each month until Sunday, 6 p.m. For Ella, you're going to be seeing Ella on the 1st, 3rd, and 5th, Saturdays and Sundays from 10 a.m. to 7 p.m. And this will take and continue until she turns 3 years of age. Once Ella turns 3, then the schedule will change to the standard possession order. And then all medical expenses that are not covered per the medical support are going to be split 50-50. Is this your agreement, Mr. Cardosa?
Yes, ma'am.
Okay, and now in reference to the community property, you and Ms. Cardosa have also entered into an agreement. Part of the agreement is that each one of you will keep any and all personal belongings and property under your name. Each one will keep their own debts also under their name. And that both of you will have, you will have 50%, you'll be entitled to 50% of their retirement from Ms. Cardosa for her employment with Guided Stone. And that would be from the date of marriage, the day that the court signs the divorce decree. And then also there will be a right of first refusal as part of the possession order. That means that if you are going to be gone for more than 24 hours, you will let Ms. Guerrero know, and she will have the right to have possession of the children, and the same thing will apply to you. Mr. Cardosa, you heard the terms and conditions that I read into the record. Is this your agreement, sir?
Yes, ma'am.
Okay. And Your Honor, we have one issue. I'll leave it for the end, and then I pass the witness.
Okay, Mr. Contreras?
No questions of Mr. Cardosa. I do have questions of Ms. Kathleen Guerrero Cardosa.
Go ahead, sir.
Ms. Cardosa, you go by Kathleen Guerrero, is that correct?
Yes,
You never changed your last name, is that correct?
right.
You heard what's read into the record regarding the
Yes,
the visitations, the child support, the health support, reimbursement, the dental support. And you feel that those orders are in the best interest of the children? Is that correct, Ms. Guerrero? All right. And as far as the community property division and the community property debts, you feel that is a fair and equitable division of your community property? and debts, is that correct?
Yes.
And you asking for divorce as well, Ms. Guerrero?
Yes.
Now, there was one issue that is left behind, and that is the issue of visitations, or summer visitations, that is, specifically July. You asking this court that the standard visitation schedule continue into July. And there's concerns that he had this year. You understand that next year is going to be a standard possession orders that the court is going to, or should I say that the summer visitations will come into play as far as those visitations. You understand that, Ms. Guerrero?
Yes.
What is your concern this year regarding July? What's the biggest concern you have, Ms. Guerrero?
And Judge, if I can interrupt you, I was confused on that. If it's only for the year, then we're in agreement. I can read it into the record, Judge.
Okay.
Mr.
Mr. Contreras?
Did you hear that? That this year that it's going to be standard visitations into July, and then next year the standard will apply for the summer. Do you understand that, Ms. Guerrero?
I'm sorry, what? Can you repeat that?
Mr. Guerrero, agreement that this year will follow the standard possession orders.
Judge,
into
I'm
July.
having a lot of.
Yes, we can't hear you, Mr. Contreras. Ms.
I can assist the court.
Go
Judge.
ahead, Ms. Lopez Singletary.
Okay. So basically, Ms. Guerrero, then your agreement will be that for the summer, for this summer of 2022, father will see Tristan on the first, third, and fifth Friday, 6 p.m. through Sunday, 6 p.m., which is the same possession order that he has. Ella will continue with the same possession order Saturdays and Sundays on the first, third, and fifth from 10 a.m. to 7 p.m. This schedule will only be for this year, Ms. Guerrero. The following years, we're going to go back to the standard possession order. Is that your agreement, Ms. Guerrero?
Standard meaning what?
Starting next year, he would get his 30 days if he lives within 100 miles and 42 days if it's more than 100 miles.
Right, for the one older, for the 4-year-old, right?
Yes. And then for Ella would be until she turns 3.
Correct.
Yes.
Okay. Okay. And then one more thing, Judge, they are going to, their agreement is that there'll be no retroactive child support or medical support. In exchange, father is going to be waiving his second and fourth Thursdays of the month to have a 0 retroactive child support as of May the 16th, 2022, Your Honor.
Okay. Well, you just need to word it differently only because you cannot give up a visitation in exchange for money. So it's something, I understand what you're doing, but you can also say that it's for continuous, like a continuous schedule so that it doesn't interrupt their week or something.
And that was the issue that we had, Your Honor, and I've called Mr. Contreras on that, Judge. I've told Mr. Cardosa that the parties can agree to otherwise, you know, if he's unable to pick up the child. But as per the code, we needed to include that there, Judge, and I needed guidance. I wasn't able to tell. Mr. Contreras and I have been very good in working everything out, Judge, but that was one of the concerns that I had on that provision, Judge.
Yes, that's the thing with Thursdays. The parent can't always make it on Thursdays. That's why you have a paragraph that says that as per mutual agreement, so that if they can't pick them up, they can't pick them up. It's not necessarily like, don't pick up a police report every single time or anything like that. It's just, you know, if
Use
they
certain
can't-
language already.
Yes.
I use certain language already, but I can put that in the language.
Okay,
to
only
satisfy the
because
second part.
you can't exchange visits for, but you can certainly do it however you want. You just can't word it for that
Yes,
way.
Your Honor. No problem.
Okay, so work it out to get it. I'll give you some time. Okay, first of all, let me take judicial notice of all the documents in the court's file. And I'm granting the relief as requested and testified to on the record. And so I'm granting the divorce today. And I do find that it is in the children's best interest and the property division is fair and equitable. So I'm going to give you some time. I'm going to give you until June the 24th. I'll set a tickler for that so you can get all the language worked out and circulate the divorce decree for signatures. So you have to turn it in by June 24th, okay?
Yes, Your Honor.
All right. So if you need any more guidance, just let us know, but just careful on the wording for that retro.
And then,
Thank you
Your
so
Honor,
much, Judge.
is that's going to be a tickler then? And if we don't have an order, we can always come back, right? Because
Right.
that's something that's been going back and forth. Judge, I just want to get it resolved. The parties want to get divorced already.
Right, it's a tickler, so if you don't have it done by then, we'll have a show cause
Okay,
hearing.
perfect. Thank you, Your Honor.
Thank you so much.
Mr. Cardosa, did you have any other questions?
No, ma'am.
Okay, thank you.
Okay.
That's all we have. Can we be excused?
You certainly may.
Thank you.
Thank you, Judge. Have a
Okay,
good day.
thank you. Y'all have a good day.
Bye-bye.
Okay, Mr. Guerrero, can you hear me? Attorney Fabian Guerrero.
Yeah, yes, Your Honor. I'm present, Judge, on two cases.
Okay, so we have F 0438-22-9 in the matter of the marriage of Miguel Vargas versus Crisela, Cricela Gonzalez. I know she has Trejo, but she's under Gonzalez for this divorce. So are you ready with an agreement?
Yeah, yes, it's an agreed to divorce, Judge. I can dictate the terms if the court wants to.
Okay.
I'll swear them both in.
Sure. Let me have you both raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Ms. Trejo?
Buenos días. Disculpen,
Oh,
yo no entiendo inglés.
está muy bien. Okay. Ms. Castañeda, please translate.
Ms. Trejo, ¿jura que puede levantar su mano derecha? ¿Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
Okay. And Mr. Vargas, do you prefer English or Spanish?
English.
All right. And sir, raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you may lower your hand. Mr. Guerrero, go ahead and dictate the terms on the record.
Certainly, Judge. I just had like the court to take judicial notice of all documents on file, including the fact that my client did fulfill the jurisdictional requirements to filing this petition in this county and in this state. Mr. Vargas, you've entered into an agreement with your wife regarding this divorce. Is that correct, sir?
That is correct.
Okay, and pursuant to your agreement, you will be joint managing conservators with Crisela Gonzalez as the primary. Is that your agreement, sir?
That is correct.
Okay, and due to your work schedule, your visitation period, you will have possession of your child every weekend beginning at 6 p.m. Friday and ending at 6 p.m. Sunday. Is that your agreement with your soon-to-be ex?
That is correct.
Sir, and you're also agreed that, or she has agreed with you, and we'll ask her to confirm this, that she will give you notice every time prior to traveling outside of the United States with the child in this case. Is that your agreement, sir?
That is correct.
And you've agreed that you will pay your child support at $250 a week. Is that correct, sir?
That is correct.
And using our standard work year, that translates to $1,083 a month. Is that your agreement with your spouse?
That is correct.
You will also agree to maintain health insurance for your child through your private insurance company. Is that your agreement, sir?
That is correct.
Now, insofar as community property, you both have not accumulated any significant community property other than your personal effects. You're asking this court to award you all your personal effects, including the clothes that you have, your things that you might have with you as your separate property, and do likewise for your spouse. Is that your agreement?
That is correct.
And you're also asking that insofar as indebtedness, that you have no significant community debt, excepting that all debt that you've incurred during the time that you're been separated, and of course, all the debt that she's incurred will be awarded as your respective separate debts. Is that your agreement, sir?
That is correct.
And you believe that these terms and conditions of visitation and access are in the best interest of your child?
Yes, sir.
And you believe that the division of the marital estate, including the debts, is a just and right division, sir?
That is correct.
And you're asking this court to grant you a divorce. Is that correct, sir?
Yes, sir.
Okay, I'll pass the witness, Judge.
Okay, do you have any questions of Ms. Gonzalez Trejo?
Yes, I do, Your Honor, if the court will allow me.
Yes, just go slow so that Ms. Castañeda can go ahead and translate.
Ms. Gonzalez, you will be joint managing conservators with your husband, is that correct, ma'am?
Ms. Trejo, usted va a ser conservadores de gestión conjunta con su esposo, ¿correcto?
Sí,
Yes.
And you will be primary, is that your understanding?
Y usted va a ser primaria, ¿ese es el acuerdo?
sí,
Yes.
And because of Miguel's work schedule, you will allow him to visit with your child from beginning Friday at 6 and ending Sunday at 6. Is that your agreement, ma'am?
Y por el trabajo del señor Miguel, el acuerdo es que él va a visitar a los niños comenzando el viernes a las 6 y terminando el domingo a las 6, ¿correcto?
correcto.
Correct.
And you have also agreed to give Mr. Vargas notice anytime you intend to travel outside of the United States with the child. Is that your agreement, ma'am?
Y también le va a dar aviso cuando va a viajar fuera de los Estados Unidos, ¿correcto?
Sí,
Yes.
And Mr. Vargas is paying you $250 a week as child support. Is that true and correct, ma'am?
El señor Vargas le está pagando 250 a la semana por los niños, ¿correcto?
sí,
Yes.
And your agreement is that he will continue this payment pattern.
Y
Is that
es
correct?
su acuerdo que esto va a continuar, ¿correcto?
sí,
Yes.
And Mr. Vargas will insure your child. Is that correct, ma'am?
Y el señor Vargas va a tener el aseguro con el niño, ¿correcto?
sí,
Yes.
And likewise, you'll keep your debts as your personal debts
Y
and whatever
sus
you have
deudas
in your possession.
Sus deudas personales se van a quedar con usted, lo que tenga usted en su posición, ¿correcto?
¿cómo, perdón?
Sus deudas personales y sus cosas personales se van a quedar con usted.
Ah, sí,
Yes.
And that's your agreement, right, ma'am?
Y ese es el acuerdo, ¿correcto?
sí,
Yes.
You requesting any name change by chance, Ms. Gonzalez?
Ms. González, ¿está usted pidiendo un cambio de nombre?
no,
No.
Just clarifying. And ma'am, that's it, Judge. That's all the questions I have.
Okay, then clarify to me, ask her then, Ms. Castañeda, what does she claim her name to be?
¿Qué es su nombre?
Grisela Trejo González.
Grisela Trejo González.
Okay, and is she keeping it like that?
Y se va a quedar con ese nombre así.
Grisela Trejo González, sí.
Yes.
Okay. Okay. And ask her if she feels that this is an equitable, well, did you say they had no community property, correct?
They accumulated no community property other than they're going
Okay.
to keep their personal effects, Judge.
Okay, so can you please ask her if she feels that it is a just and right division of the community debt?
¿Usted cree que este fue un justo y correcto tocante a las deudas? La división.
No.
¿No cree que fue justo y correcto la división de las deudas?
Oh, sí, sí, fue justo.
Yes, yes, it was just.
Okay, and the visitation, possession, access, and terms regarding the children, does she feel that those are fair and in the children's best interest?
Y tocante la visita, la posición y el acceso, ¿también usted cree que fue justo?
Sí,
Yes.
un detallito.
One,
Yo pregunto, ¿es justo que yo sepa la dirección de donde está mi niña cuando está con su papá o no?
Is it just for me to know the address of when she's with her dad or not?
She's entitled to know where her soon-to-be ex-husband lives as to the address. He does not have to report to her every place the child is when he has her in his possession for visitation.
Ok, usted puede saber la dirección del señor, pero no tiene por qué saber dónde están cuando él está con posesión del niño.
Okay.
Ok.
How old is the child?
¿Qué edad es del menor?
3 va a cumplir 4 el 22 de este.
3, he'll be 4, or they'll be 4 the 24th.
Okay, and it's just one child.
¿Y es nada más un
Sí.
menor de edad? Yes.
Sí.
Okay. Okay. All right, then the court is taking judicial notice of all the documents in the court's file. The court is granting the relief as requested and testified to on the record by the parties, and finds that this is a fair and equitable distribution of the debts, and that the terms with respect to the minor child are in the minor child's best interest. So do you have a divorce decree already executed, or when will one be executed?
I'll have one prepared, Judge, and we'll circulate it. Make sure that my client signs and the respondent Gonzalez signs also, Judge.
Okay, do you have her contact information?
Yes, I believe we've been in communication with her. That's how we got the agreement. Let me see. I've got her address and I have her phone number, Judge. I don't want to repeat it over but I do have her phone number.
Okay, well, what we'll do is I'll give you until June the 3rd. I'm just gonna set a tickler. So June 3rd to submit the FDD.
Okay.
I'm sorry,
Thank
the
you, Judge.
final divorce decree. All right, anything else?
That's it for at least
For this case, I know
I've
you
got
have one more. Okay.
one
So,
more,
Ms.
yes, Your Honor. I have
Castaneda,
one more.
please let Ms. Trejo Gonzalez know that Mr. Guerrero's office will contact her, and she does have to sign off on that divorce decree, and I'm giving them until June the 3rd to turn it in.
Ms. Trejo, el señor Guerrero va a circular el decreto para su firma y la corte les dio hasta el día 3 de junio para entregarlo.
Okay.
Okay, if nothing further, then the parties are excused.
Ms. Trejo se puede retirar.
Gracias.
Thank you.
Thank you.
Okay, thank you. Let me call your next case, F0108-21-9, in the matter of the marriage of Victoria, Viktoria Molina, and Silvano, Silvano Molina. Okay, Mr. Guerrero, was there an agreement?
Your Honor, there was a substantial agreement and we recited that prior hearing. And we actually have an agreement excepting for one issue. The amount of child support Mr. Silvano would be obliged or obligated under the code to pay Victoria Molina in this case. We could not reach an agreement. But we did get income information from Mr. Silvano. Based on the income information and 2 children that are going to be in the custody and possession of Victoria Molina, Judge, we've calculated an appropriate amount of monthly child support.
And what was that amount?
The amount of appropriate child support based on his monthly gross income of $4,166.67 is $873.63 a month, Judge, for 2 children.
Okay, and Mr. Molina, what's the amount that you think you should have been calculated to pay?
And my response to that is that's just way too much. My opinion would be maximum like $500 that I could do.
And what are you basing that on?
On just current stuff that I have to pay, bills.
Oh, no, I'm sorry. We don't do it like that. So the law says that we get your pay, which Mr. Guerrero got, and what you ended up submitting to him, and then he runs it according to the family code, and he'll give you credit for any taxes that you're supposed to. So he's not doing it on the gross; he's doing it on the net. So they'll calculate your net, and then they'll give you credits that you're allowed under the family code, and that's what the amount is. Now, based on Mr. Guerrero's amount of time that he has been practicing law, I have all the confidence that he has calculated that child support amount correctly. Okay, now if it doesn't fit your budget, that's different. So it's not what you think you can pay. It's what the law says that you have to pay. And so once we calculate what your child support obligation is, then you work your bills around that amount.
I wish
Child
life was that
support
way.
is always paid first, sir.
Yeah, I wish life was that way. You could, rearrange your bills and stop life as it is, but that's not the case.
Well, first of all, I'm going to ask you to sit up, okay, and stop with your lax attitude. Put your arm down and talk to me right. If not, what I'm going to do, face the camera properly.
I am.
No, you're not.
It's a sideway camera.
Okay. So you're not going to be talking to me like that. Do you understand me? Because I'll go ahead and stop it and I'll bring you in person.
Yeah.
So not yeah.
Yes, ma'am. Or yes, Judge.
So it's not about how life is. I wish life worked a lot of different ways, but it's not. But I'm not the one getting a divorce today. You are. Okay. So I've given you plenty of opportunities to hire an attorney and you chose not to. And I don't want to hear why. I'm assuming, because you've already told me, that it's your financial situation. That's not my problem. I'm trying to work with you.
Yeah, I understand. Thank you, Judge.
And so there's nothing I can do about the child support amount. That is what it is. It's just numbers. And if it doesn't fit your budget, I'm sorry, there's nothing I can do about it. You need to figure out your budget. And there's changes that you'll have to make. And I'm sure you're not going to like it, because who does? But unfortunately, you are in this situation, sir. So if that is the only thing that is holding it back, then I'm going to order child support in the amount of what's already been calculated, which is $873.63. So what's the step down?
The step down, Judge, I haven't calculated the step down, but I'll do the step down according to the formula. But Your Honor, I do want to mention one more thing. there's retroactive child support as of February, so he owes 3 months of retroactive child support.
Was there an order in place?
There was no order. This is not past due child support. This is child support based not from the date of separation. They had reached an agreement to give him credit based on the sale of the home of the community. He gave my client gave him credit up until February, because the case continued to delay because of the disagreements. 3 months lapse where he has paid no child support whatsoever.
I'm sorry, Mr. Guerrero, I believe it was January.
Okay, then my bad.
Yeah, we were going to start in January. The credit from the sale of the house was as of December, and so we would start in January. So as of from January to today, no child support has been paid.
So it's 5 months, Judge. 5 months, right, Victoria?
Starting in January.
Yes.
Okay, and Mr. Molina, your response?
Yes, that's correct. That's accurate.
Okay, so then they'll go ahead and calculate that retroactive support and just take a judgment. And how much is he going to be paying that on?
It'll be, I'm suggesting $50 a month, Judge.
Hold on, let me check to see. Okay. It would have to be at least 75 to cover the interest.
Okay.
Plus over that.
All right.
So it has to be at least at $75 a month.
Okay, we'll mark it at 75 a month.
Okay, so in the decree, please include the step down. So they already testified to us to the terms of the agreement?
Yes, Judge, this is a divorce and a motion to modify based on the fact that Mr. Silvano left and is living in Mexico and the children are now in Victoria's custody. We had gone back and forth and we had agreed that Victoria would be the custodial parent. That's how why we ended up having some child support being due and owing to Victoria. In the interim, we also agreed to sell the community property, which is the house that was in the decree, and that was sold, and that money was distributed, and those credits were given. So this is a modification, Your Honor, of an
okay.
existing divorce decree.
Okay, so go ahead and get that final order submitted to me by by June the 3rd.
June 3rd.
And
Yes,
if
Judge.
it's not, it needs to have a signature, but if you get difficulty in having it signed off, go ahead and just submit a motion for entry and we'll set it for hearing.
Okay, I'll get my client to sign and I'll circulate it to Mr. Silvano if it tracks the language of the agreement and the court's rulings, he should sign.
Okay, all right, anything else?
Nothing else from us, Judge. May we be excused?
Yes.
Thank you.
Okay, Mr. Cavazos, Mr. Ramirez appeared earlier and he did say that his client had missed some visits. I'm on F4436-21-9, but that you all were still talking. So go ahead.
Good morning, Judge. Yeah, for some reason I got kicked off and then it wouldn't let me sign in. I did speak with Mr. Ramirez. I know we have a reset, Judge. I'm fine with that.
Okay.
It's just, my understanding is he mentioned that his announcement was she had missed one. She's missed since March, Judge. She's missed quite a bit of them. So I just wanted to put it on the record that I believe the last one that she made was on March, at least what my client is telling me, March the 6th. And he was concerned because he's showing up 2 or 3 times a month sometimes, and she doesn't show up with no notice.
Well, is there a clause or does she have to give him notice that she'll be exercising visits?
See, that's where the ambiguity is that that she was, but then on some occasions she says I'm going, but then she doesn't show up for whatever reason, and she didn't show up at all in April or at all in May. She didn't. I don't even remember. We kind of talked about birthdays. We arranged it. She showed up. That he shows up. She never showed up for the birthday. So the children, of course, are getting a little bit depressed, and then he's getting frustrated. So
yeah, I think what we're gonna do is, I did say June the 13th, but what I'm gonna go ahead is I'm gonna have one of my staff members contact you on Friday.
Mm-hmm.
And have you and Mr. Ramirez on the phone. And I think we're gonna set it up for an in-person status so that I can talk to them or talk to her if she shows up.
Okay, Judge.
And then that way, but I'll just want to make sure that you all are on so we can calendar it on a day, on a Wednesday that you all are available.
Okay, Judge, would that be in the morning or would that be in the afternoon?
It can be either according to your schedule.
It usually works. I know for myself, it works better in the afternoon most of the time.
That's fine.
We're done with court. But whatever at the convenience of the court, Judge, and I really appreciate your patience with this.
It's not a problem, but sometimes when you bring them in, it's different.
I agree.
So that's fine. Then we'll set it up for a Wednesday afternoon, the first Wednesday afternoon that both of you all are available.
Perfect, Judge. That's all I have, Judge, and I appreciate you taking my case.
All right, no problem. Thank you.
Take care. Yes, Judge.
Okay, Miss Angie. Can you unmute yourself and give me your full name?
Yes, my name is Angelica Busby, Your Honor.
Okay. And is it ready for a divorce? Did you do everything you needed to do?
No, ma'am, I have no response from him on doing his part to getting it transferred or filed over there in Tarrant County.
Because you're living here now, right?
Yes, June 18 will be a year.
Okay. Yeah, and you still have that case in Cameron County, correct?
Yes, in Tarrant, correct.
Okay. So I'm sorry, Cameron or Karen County?
Tarrant.
Tarrant, okay. So did you file your motion for transfer venue in Tarrant County?
No, ma'am, because do I need to live over there though?
No.
Okay. That's what stopped me because I was confused with that question that says that I have to reside in the place for 6 months.
No. You filed properly here technically, but because you have the case with the kiddos and your, right? Because they did the case of the child support, all that is out of Tarrant County, correct?
Yes, ma'am.
Okay, so you need to file a motion to transfer venue in that county. Tell them that you're transferring it over here on this case number, and then we can do your divorce.
Okay. I have another question. Will it be necessary since I will no longer get child support after June 2nd?
Okay, so once your child emancipates, is it because the child is graduating?
Yes, ma'am.
Okay, so when does the child graduate?
June 3rd, but as per child support office, I was told that I would no longer get it after June 2nd.
Correct.
So if there's like a pay that falls, then I guess I get that during that week or the following Monday or so.
Right,
But
okay,
that'll-
so then you are correct. What happens is then that issue is what we call moot, like, you know, it, because now you're divorced, but are you gonna be asking for retroactive child support or arrears or anything like that?
Yes, he does have arrears.
Okay, so
And
then
then I was told by the, go ahead.
I was gonna say, if you're gonna have arrears that you have to include in your divorce decree, you still have to do the transfer.
Okay.
Because it's dealing with your child.
Okay.
So I'll go ahead and give you some time. I'm gonna reset you to August the 29th. At 9:30.
August 29th at 9:30, you said?
Yes.
Okay, thank you.
Okay, ma'am. You have a good day.
Thank you, you too, girl.
Okay, did anybody call in on number 11?
Judge, on number 11, I noticed that there was an order resetting filed. They had previously they filed a Rule 11, Judge, and we're just pending it now, the order resetting, but it has been filed, Judge.
Okay, number 12?
That one, Judge, I don't believe anything, but let me just check quickly. No, Judge, nothing was filed, Your Honor.
Okay, number 13?
On number 13, Judge. The same announcement, Judge, nothing was filed.
Okay. All right, so then numbers 3, 5, 9, 10, 12, and 13, set them all up for the drop docket.
On number 9, Judge, I did notice that proper notice was not sent, so I'll reset the final hearing, Judge. But the rest I will set for DWAP.
All right. Okay, that concludes this morning's